myself Suresh Thakur, and today the topic which we are discussing is the meaning of Hindu. Who is a Hindu under the Hindu Marriage Act 1955? That's what is the topic for today. Now, Section 2 of the Hindu Marriage Act 1955, it talks about the application of the Hindu Marriage Act 1955, and so also it also defines that who is a Hindu. Section 2 of this act, it defines the term Hindu in three parts. तीन parts में ये divide करता है हिंदू की जो definition है उसको. So we will be discussing that in one and the other part. And the first part which deals with this, and it says any person who is a Hindu by religion in any form, whether that is in Arya Samaj or that is Brahm Samaj or Satsangis, all these persons who are following the Hindu religion in such forms, they are to be treated as a Hindu. There is a case on this point which is decided by the Supreme Court of India, that is Sastri versus Mooldas. इस केस में सुप्रीम कोर्ट ने ये कहा कि चाहे कोई आर्य समाजी है या ब्रह्म समाज को फॉलो करता है, प्रार्थना को फॉलो करता है और कोई सत्संगी भी है, so all these persons they will be treated as a Hindu because all these different sects they have emerged from the Hinduism itself. So one thing. Secondly, it says that all persons who are Buddhist, Jain or Sikh by religion, such person will also be treated as Hindus. Third definition of Hindu which is prescribed under section 2 of the Hindu Marriage Act. Now it is in the negative form. जो अभी तक दो पार्ट में हमने अभी किया वो एक पॉजिटिव फॉर्म में हिंदू जो टर्म है उसको डिफाइन करते हैं. थर्ड थिंग इट सेज दैट एनी पर्सन हु इज डोमिसाइल्ड इन इंडिया but who is not a Muslim or a Christian, Parsi or Jew, such person they are also to be treated as Hindu. तो एक नेगेटिव सेंस में हिंदू की डेफिनेशन को तीसरा जो ये पैरा है वो इसको ले डाउन करता है कि अगर कोई पर्सन जो डोमिसाइल्ड है इंडिया में बट हु इज़ नॉट अ मुस्लिम, नॉट अ क्रिश्चियन, नॉट अ पारसी और Jew, that person will also be treated as Hindu. Section 2 further has three explanations which are attached to section 2, which also defines the persons who are to be treated as Hindu. The first explanation, it says that any child, whether that child is legitimate child or illegitimate child. Now if both the parents of such childs they are Hindu, and in that case or in Hindu that means whether they are Hindu, Jain, Buddhist or they are Sikh by religion. So if in such a case that person or that child, both of whose parents they are Hindu, that child will be treated as Hindu. Second explanation, it says in that case where not both the parents are Hindu but one of the parent is a Hindu, and it says in that case where one of the parents of a child is a Hindu, irrespective of the fact again कि चाहे वो बच्चा इलेजिटिमेट है चाहे लेजिटिमेट है, अगर दोनों पेरेंट्स में से एक भी पेरेंट अगर हिंदू है एंड दैट चाइल्ड इज ब्रॉट अप एज अ हिंदू, इन दैट केस दैट चाइल्ड विल ऑल्सो बी ट्रीटेड एज अ हिंदू. In this point also there is a case Sapna versus State of Kerala. In this case the Kerala High Court said that it is very important aspect that a child must be brought up as a Hindu if only one of the parent is a Hindu. In this case the mother was a Hindu who was married to a Christian male and a daughter was born to that wedlock, and in this case Kerala High Court that gave the judgment that since the child was not brought up as a Hindu, so she is not a Hindu and that child will be treated as Christian. Further, third जो explanation है वो converted Hindus की बात करते हैं और the reconversions of the Hindus. If any person who has converted to Hindu religion, that person will also be treated as Hindu. Further, if any person has converted to any religion other than Hinduism, and again that person converts, reconvert अगर कोई करता है Hindu religion में, so again that person will be treated as a Hindu. So this is the definition of the Hindu under the Hindu Marriage Act 1955.